The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to the afternoon argument in the Kansas Supreme Court. I would like to welcome counsel, the respondent, as well as those who are watching us on our Supreme Court Live channel. I'd like to take a minute before we start today to introduce, we have a visiting judge today, Judge Christina Dunn-Gillenberg, who is sitting with us in the open position created by the recent retirement of Justice Carol Byer. The judge is a district court judge in the 10th Judicial District, which is Johnson County. She has served as a judge since August of 2012. Judge, we thank you for taking time from your busy schedule today to help us out. We are very honored to have you join us. Thank you.
Thank you, Chief Justice. The honor is all mine.
Counsel and respondent, as you know, all of us, including our visiting judge, have had the record and the briefs that you've submitted, and we look forward to the arguments that you make today. With that, I will ask Mr. Doug Shima, the clerk of the appellate court, to please call this afternoon's docket. Mr. Shima?
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Friday, October 30th, 2020 consists of one case, appeal number 122565 in the matter of the Honorable F. William Cullins, original action in judicial discipline, briefs both sides. The examiner, Mr. Thompson, has reserved 3 minutes rebuttal time. Respondent will split time by counsel arguing 13 minutes and the respondent arguing the remaining 2 minutes. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. This time I would ask that you please state your appearances for the record.
May it please the court, Todd Thompson, appearing as examiner for the Commission on Judicial Conduct.
May it please the court, Chris Joseph, appearing on behalf of Judge Cullins, who is also appearing by Zoom.
Thank you. With that, Mr. Thompson, you may present your argument.
Thank you, Your Honor. This is a judicial discipline matter. In this particular instance, there were complaints filed against the respondent alleging that he used obscenities around the courthouse and in dealing with employees and other people at the courthouse. To some degree, respondent acknowledged that that was a fact. The elements or items that were found by the panel after a 4-day hearing to have been proven by clear and convincing evidence were the fact that respondent used the F word frequently around the courthouse, that he failed to give an opportunity to people to respond to him. This was attempted to be portrayed as, quote, telling his staff to listen rather than talk during a meeting. But in reality, it was very hostile language. For example, telling Lance Carter to keep your fucking mouth shut. You don't have a right to defend yourself here. Don't say another fucking word. Get the fuck out of my sight and shut the door on your way out. Also, go sit down in that fucking chair and don't say a fucking word. That is not telling his staff to listen, and that is what the panel found. He also was found to have cursed loudly and angrily out in the public area of the courthouse at Joni Pratt in front of some carpet layers. And there has been an attempt in the reply brief for respondent to downplay that incident, but I want to note his own comments were that he did repeatedly cuss. These are all in volume 9, pages 736 to 738. He acknowledged that he got irritated with Pratt, that Pratt came back to see him as soon as he got back from lunch, that she was upset, and that in hindsight, this is his testimony, in hindsight, he can see how she was embarrassed by the way he behaved in yelling at her about her request to put carpet in the elevator. He also referred to the people who overheard him yelling at her as fucking inmates, when in fact they were employees of a carpet laying company who were in the hallway and who were offended by what happened. This was also tried to be downplayed in the reply brief, but Mr. Brock heard the F word. He testified. Mr. Brock's one of the carpet layers. He testified he heard the F word. He talks about, quote, literally crawling back into the room where he was working. And this is a point where I think we need to note that the court should give deference to the panel's findings. The panel saw Mr. Brock's testimony. They heard the tone of his voice. They saw him hunker down as he was indicating how when this explosion occurred out in the hallway, he just wanted to get out of the way. So the panel does have a better view of determining the evidence, and they were very specific in their unanimous decision in this case. They had a better opportunity to evaluate the witnesses. But when Clerk Pratt resigned, respondent yelled, "Yahoo!" Another judge in the courthouse heard it. Ms. Pratt heard it. It was found by the panel that it was loud enough that he knew, or certainly should have known, that other people were going to hear him yelling "Yahoo!" when she turned in her letter of resignation. Former Attorney General Kurt Schneider testified at the hearing that he has heard the respondent use terms like bitch and cunt when referring to females. General Schneider also brought forth a piece of evidence that was admitted without objection, in which his secretary, Ann Rooks, called the judge to tell the judge that Mr. Schneider was entering an appearance for a client, and Judge Cullins asked whether it was the male or the female. And when Ms. Rooks said it was the female, Judge Cullins said, "Oh, fuck." Them again. And then he said, "She's fucking crazy." That was recorded instantly or almost instantly by Ms. Rooks, and that document was admitted into evidence. That's important too.
Mr. Thompson, could I have a clarification on the derogatory characterization of women that Mr. Schneider testified about? When did those characterizations take place? Was that in the courthouse, where was it just general conversation? In what context were those characterizations made?
Mr. Schneider testified that it was, quote, many times in the courthouse, that he did not socialize with the judge. So there were no out of the courthouse episodes, that those comments were made many times in the courthouse.
Mr. Thompson, would you consider those statements, if true, that were made to Ms. Rooks that you just recited, to be an ex parte communication or not?
By Ms. Rooks just entering an appearance for Mr. Schneider and letting the judge know?
No, the comments that Judge Cullins allegedly made on the telephone during the conference.
My bigger concern would be the fact that he's telling a lawyer's office that he has a bias against that client right out of the chute. She's crazy.
I understand that might be a bigger problem, but was it ex parte?
Well, it was initiated by the attorney's office. No one else was on the technically it was an ex parte communication. Moving on to Mr. Emmert, another senior attorney in the area. And I think that's important because there's always in these cases a fear of testifying against a sitting judge. And in this case, two of the primary witnesses, certainly not all of the witnesses, but two of the primary witnesses were individuals who were at the end of their career. Indeed, Mr. Emmert said he was in the process of retiring, who no longer had to fear retribution from a sitting judge. Mr. Emmert, in his, on his way out, if you will, made very strong comments that he had heard when sitting in chambers or out in the clerk's office, Judge Cullins used a number of obscenities, again, including the words bitch and cunt. And he said that obscenities from Judge Cullins were simply, quote, routine. General Schneider said that it was just all the time, that there were many of them. So it was not a matter that they weren't able to pin down a time, as has been suggested. It's just that it happened all the time. And based on the evidence, the panel came to the very explicit conclusion and stated that they were convinced that Mr. Emmert told the whole truth. They went out of their way to make sure you understood that was their conclusion, having the ability to evaluate the various witnesses. Respondent stipulated that he wrote on a court document, Larry said so, doesn't fucking cut it, and sent the document back. So that is not a matter of dispute. And it's another example that the respondent does not exercise care at all in choosing his choice of words. And yet that is one of the defenses that has been asserted here, is that several witnesses came forward and said they had never heard obscenities. Therefore, you, the court, should ignore the findings of the panel and conclude that there was not clear and convincing evidence. Now, in my mind, this is the same as if you interview 100 people and 95 of them say, I never heard him say that, but 5 of them very definitively say, he said it, and you believe them, then that is clear and convincing evidence. It is not a matter of purely quantity over quality. So this suggestion that it is highly improbable that he would have used these derogatory words is simply not a good argument for the respondent to make. For example, he used the word boy in referring to 2 Black athletes who were in front of him. He himself says he regrets using that word a couple of times, that it was a terrible word choice, that it slipped out, he shouldn't have done it, and that it's not been a good thing for the entire judiciary. Those are his words. So you should not be asked by someone who clearly has been shown to have a terrible choice of words to ignore the findings of the panel.
Counsel?
Yes.
A factual clarification. Was there ever an incident when Judge Cullins used the word boy in isolation, or was it always in a phrase?
I believe the transcripts reflect in a phrase.
Okay, so it's
I think that's one of the reasons that I made it very clear that I was not alleging or asking the panel to find that he was overtly racist.
So well then what was the basis for the complaint as it related to the use of the phrase Kansas boy?
The fact that he created a situation in his courtroom in front of witnesses, the defendant's family, in which there was a perception of bias or racial lack of awareness by the judge sitting at the top of the courtroom.
So, well, and let me just delve into that a little bit. Is there a difference between bias and racial insensitivity? And let me follow that up by saying, if the judge had used a phrase like "good old boy," would we be here?
Well,
On that count.
we'd still be here, but maybe on that
On that
particular
count.
one. Yeah. I don't know the answer to that because I hadn't given that particular issue thought, but I think in referring to someone as a boy, it was, as he said, a horrible, terrible choice of words to utter in a courtroom when the defendant is a Black individual.
So you think that had the judge said, "They're just good old boys," that would not change anything?
Well, it doesn't really fit in the setting that he was making the comment about, where he was trying to pin down their location, where they were from. And I see my time is up.
Counsel, I want to direct your attention to the panel recommendation. It's on page 14. I'm trying to decipher it, I guess. The panel's got a notion here that we do public censure, require professional coaching of a minimum of 1 to 2 years, but if the respondent fails to complete whatever that recommended coaching would be, that we suspend him from his judicial duties, which the way that's worded, maybe it's just me, but it seems like that's reversing it. Are we to understand that the panel believes that the conduct that it has found actually warrants suspension from judicial duties, and the public censure and the professional coaching is really just a way out of that? You see what I'm asking?
I think I do. And I would answer your first part of that. Yes, I think it's clear that they felt it warranted suspension, but in considering the efforts that the respondent had already made, the situation in terms of availability of experienced judges in certain parts of the state, et cetera, that they opted, and frankly, respondent sort of requested that he finish this training while staying on the bench. And I think that's what they opted for.
I mean, from my perspective, this is telling me that public censure alone is not enough, that this misconduct is so serious that it warrants suspension. And then it provides this alternative. So I'm just trying to place that, but clearly suspension would not be warranted unless this conduct was so serious as to support it.
I agree with what you said in the prior phrase, that they thought it warranted suspension, but they opted, if you will, for the public censure with conditions. And if those weren't followed through, then there's no hope. And so you go ahead and suspend. Is there any other question? Thank you.
I have a
Sorry.
question briefly, very quickly. Counsel, were exhibits 43 and 44 admitted into evidence? They're part of the record as those exhibits. Were they available to the commission?
Can you describe those for me? I don't have the exhibit list in front of me.
I believe they're the transcripts of the hearings in which Judge Cullins addressed the African-American athletes.
Yes, those were admitted.
Okay, any other questions? Okay, thank you, Mr. Thompson. Mr. Joseph?
May it please the court. I'd like to start with what I think is the most significant findings and most damning findings, and that's gender and racial bias. That's what I want to focus on initially, at least. These allegations were not proven by clear and convincing evidence. And the gender bias is where I want to start. It came only from the testimony of Tim Everett and Kurt Schneider. And I implore all of you to go back and read those transcripts in detail. We're not talking and we're not challenging credibility of the witnesses. That's something that the panel found they're credible. What we're talking about is whether or not there's the quality and quantity of evidence that's sufficient to show gender bias in the performance of judicial duty. And I think when you look at it, there isn't. I mean, it's not even particularly close. I want to start with Tim Everett. Tim Everett testified, when you go back and look at it, that I have not had a lot of contact with Judge Cullins personally, but the personal contact he has had has been good, except for vulgarity. When asked about these offensive words about women, his recollection was, quote, we'd had some conversation about a woman in the system. And then he says, Mary Cadle and Joni Pratt. He did not know when the conversation occurred. He guessed it would have been right before they were terminated. He did not say anything about where or why or the context for why this strange conversation would have happened with somebody that he did not know very well.
Counsel, do you concede that he referred to a woman at some time or another as the B word?
No. No, absolutely not. That is not established by clear and convincing evidence. That's the issue.
But you concede he's used the B word, but only to indicate griping.
Correct. Correct. So Mr. Emmert also acknowledged, and here's where perhaps, I mean, I'm not suggesting he went up there and lied. I think he went and told the truth, just like the panel said, is what best of his memory. He was close friends with Joni Pratt, who vented to him and talked to him about Judge Cullins all the time. And the real dagger, I think, is the fact that his partner, Dan Reynolds, credibly, and according to the panel, credibly recalled Emmert telling him in the past that he didn't personally hear any of this. This is something that he was told. Now, I don't know how you reconcile those two, and I think that's the real problem. The panel couldn't figure that out either, so they ultimately speculated. Here's how it could possibly reconcile. That's not enough for clear and convincing evidence to show it's highly probable that he acted with gender bias and in the performance of judicial duty. Kurt Schneider's testimony is even weaker. He acknowledged, first of all, showing gender bias himself. He acknowledged that his concern was that he cursed in, quote, mixed company and in front of, quote, wives and daughters. On direct examination, he didn't make that claim. He never said in direct examination that Cullins used those specific words. It was in response to a panel member's question, and his answer, and this is the part you should read, was, quote, I think I have heard over the years those things described in the complaint.
Counsel, in reference to your comments about Kurt Schneider's bias, because he's talking about mixed company, does your client concede that he said in the phone call to Ms. Rooks that a woman was effing crazy?
Yeah, but we acknowledge that there was a conversation with Ms. Rooks, that a close friend, where he gave his perception of the case, which is inappropriate and constitutes a violation. There's some things that we acknowledge are problematic.
You don't think that shows gender bias?
No, because he says the man is crazy. Now I think she is too. There's absolutely nobody's alleged gender bias in that. I mean, the allegation was, and again, it's inappropriate to be having this conversation. And we acknowledge that, even with a friend, kind of a on the side conversation. Now I'm thinking they're both crazy because of things that happened in the courtroom testimony about them leaving garlic in front of the door, and and seances. I mean, So that's what he's talking about. It's nothing to do with gender. It's actual crazy behavior. And he shouldn't have made that comment. I don't think that's suspension. I think that is bite your tongue.
Counsel, you characterized the gender and racial slurs as the most serious. I guess from my perspective, I consider the most serious aspects of this to be the judge's hostile work environment with our employees in the courthouse. And there doesn't seem to be a lot of dispute in the evidence about that.
Well, the dispute only goes to the extent of what is alleged. Now, the findings simply cut and paste what Joni Pratt described it as. There's evidence that her description is not entirely accurate and is embellished. There's no question that he was grumpy about the carpet. He said, not our fucking building, not our fucking problem, that it was a tone that she was embarrassed about, the words embarrassed her, and that it was inappropriate. I agree, and we're conceding that we're not saying there are no violations. We're conceding that that's a 2.8 violation, but not one which he's had a 14-year career. Over those 14 years, the vast majority of folks have testified very positively about him. Some of the words used to describe him are incredibly positive about him as a mentor. And I'm looking for the words right now. Courteous, caring, compassionate, and respectful. That's 10. And we stopped because we didn't want to run witness after witness. We had 10 current and former employees that talked about how caring he is, how great he is. There are 2 who are very upset with him, and their descriptions are strong. That is not agreed. He disputed that. The panel seems to have accepted their descriptions. But over 14 years, when the vast majority of employees saying that's not at all anything we encountered, and there's 2 saying he cussed at me and yelled at me, that's a tough call. To me, racial and gender bias is more of a startling and awful allegation, which isn't there when you look at the record. But, the hostile interactions, if you'll call them, with Joni Pratt about the elevator and Lance Carter about his discipline from the Office of the Judicial Administration. I don't know if it happened quite as they described it. I think they probably embellished it. The evidence suggests that there's some, Joni Pratt said that the court reporter, Ms. Stewart, overheard this and this is how it happened. Ms. Stewart said, no, not at all. It didn't happen at all like that. She claimed that the carpet folks came up and asked her, who was that? What happened? They said, no, that didn't happen. I think you read the transcript as a whole, those are a bit embellished, not appropriate, but again, fairly isolated over 14 years when you have a vast majority of the folks, not only current, but former folks that worked up there saying he is caring, kind, generous, and they don't see anything like this. I'm not saying that he didn't have some bad behavior, and cursed and said, not our fucking building, shut the door and talked in bad tones. There's some misconduct. There's some conduct that is bad. It is not, though, representative of him. That's why we presented the mitigation to kind of explain, hey, why'd this happen? What's going on with him? And remember, this is isolated largely to that time where he takes on these administrative duties. He's having back pain. He's having anxiety. That's why we got the workup done. And that's why the panel said, I believe that's why the panel said, look, public censure is sufficient because he's addressing that. To me, it's kind of like censure is like probation. You put him on probation. If he does what he is doing now, and he's cured it all. Folks are saying everything's fine. He used to use the F word at the courthouse a lot. He's not. There is no more problems. And as long as he follows through this plan, you don't revoke probation, if you will. You don't need to suspend him. But the panel's saying censure is enough. If he doesn't do this for some reason, which, by the way, he is complying and he's doing well with it, then you can consider suspension. But that to me, Justice Biles, is what the panel was recommending, not recommending suspension, only if for some reason he is defiant, which he won't be. But to me, again, others may feel differently, but a judge that is exhibiting racial and gender bias in the performance of judicial duties, to me, is a real problem. And again, I want to go back to the last point on Kurt Schneider. I asked him for clarification about that. Did he actually remember that? And he said, I asked him, was his memory from reading the complaint or what he's read, and his answer was both. It sounds like these folks are just kind of, sounds right to me. I don't have any specific memory. And then you compare that to all the other witnesses who say, I interact with this guy on a daily basis. I've never seen any racial or gender bias. I've never seen him use words that are derogatory towards men or to women. It doesn't fit, right? So clear and convincing evidence requires it to be highly probable that he's acting with gender or racial bias. When you look at all the evidence, you don't ignore the vast evidence that sees him on a day-to-day basis, as opposed to Schneider and Emmerich, who rarely saw him and didn't see him much. You must consider all the evidence.
Counsel, from your perspective, and I know you don't want to go there, but we have to ask the question, and I think
Sure.
you need to give us your input on this. If we accept the panel's recommendation that's got this 1 or 2 years of professional coaching, as the panel describes it, what does that look like from your perspective? I know you don't want to go, but let's just
No, that's fine. That's fine. No,
we figure out how to do it, how to write it up, and you might as well have a little discussion about that.
Sure. He's working with that group that is in the report, Acumen. He is doing what they evaluated him, and they laid out a plan for him that is a couple-year plan, and he needs to comply with it. He's doing it. I think he had his most recent session with them was earlier this month. In our briefing, I think there was a July session. So it's, once a quarter or so that he's doing this individual coaching session with the folks at Acumen. And certainly we can, I think it'd be appropriate to ask us to prove compliance with it almost as if he's on probation to prove that he is doing it. And I think we'd certainly be able to do that. And for some reason he were to thumb his nose and not do that, then we have a problem. But I don't think that's an issue at all.
Can you help me with the timeline of, I've looked at the Acumen report. I don't see a date, at least on what I'm looking at. Can you tell me when that started and where he is in terms of the length of time he's been working with them?
Judge might be able to answer that specifically himself. I'll tell you, we had the evaluation performed before the hearing, significantly before the hearing, and he met with multiple providers over there. They wrote it up. Actually, before the hearing, he did the intensive 2-day group session, got the recommendations for individual sessions, and I don't remember if it was before or after the hearing where he started the individual sessions, but that is what has continued thereafter.
Okay, thank you. Mr. Joseph, would you like to more clearly then state what you're asking us in terms of sanction?
Sure. I mean, the isolated events, given the whole of his career, while there are 2.8 violations and there is the 1.2 violation for the Anna Rooks conversation, I do think that admonition is sufficient. But if you are going to give him the public censure, what matters most to Judge Cullins is that he's not deemed a racist or a bigot. I mean, the Associated Press already went out there and labeled him as such. He's not. And in public censure, he would ask that not be in there, that it be limited to the 2.8 and 1.2, and that he is fully committed. He does care, and he wants the opportunity. He's a good judge. Even by Tim Emmerich says he's a good judge. He'd like the opportunity to proceed and continue and try to do good. So if the court requires him to do the Acumen, he's already doing it. I don't think that's a problem to direct him to continue to do that as a condition of his tenure.
If you'd like your client to address the court, we can do that at this time.
Yes.
I would like to thank the court for this opportunity to speak, and I'd like to thank my wife for undying support through these last 2 years. I apologize to all the witnesses and court staff who have been impacted by these proceedings. I'm sorry that my words and actions have caused them to be caught up in this process. I've made mistakes. I've used harsh words when I should have used soft ones. I've spoken bluntly when I should have kept quiet, and I have cursed when I should not have. None of this was inspired by ill will or bad intentions. I'll do better. At the time, I was physically worn out. My back pain was significant, and it affected me during the day and prevented me from sleeping at night. But in the end, I believe I dispensed justice in my courtroom. I ran an orderly docket and I made fair decisions. I'm not sexist. I'm not racist. I've not used disparaging words about women, and I did not intend to offend anyone with the use of the phrase Kansas boy, nor did I mean for it to have any racial connotations. I have hoped that I've made a positive impact in the lives of the litigants that have appeared before me, and I hope to be allowed to continue to do so. Thank you. Any questions? I'll be happy to answer.
Are there any questions of either Mr. Joseph or Judge Cullins?
Well, what's your explanation, Judge Cullins, for what happened here? Apparently, for a point in time when you had the responsibilities that you currently have, there wasn't an issue, and then maybe 3, 4, 5 years ago, this began to escalate. What's your explanation for that, other than you're physically worn out and back pain?
Well, I think there's two things that kind of combine together. One, I naturally have an abrasive personality, and that is a personality where I have freely cussed before. And then two, I was at the time suffering significant issues related to sleep and pain. I was eventually able to figure that out, but it took a long time. It took, I think I finally started making progress at the last of 2016. Sometimes it takes a while to figure out what your physical issues are. So I think the combination of when you get lack on sleep and you get a little bit grumpier, and then you combine that with the fact that I naturally cuss, it was a bad situation.
Can you address my question about the timeline of working with the Acumen group?
I think initially I went to Acumen for a 2-day seminar on disruption in the workplace to get a better handle of, what was going on with me, but just generally how to deal with people. And then after that, and so that would have been around July of 2019. In August of 2019, I went up there for 3 days and got the evaluation, which is, I think, part of the record. And then once the hearing panel made their decision, I called Acumen and spoke with them about who might be a professional coach up there, if I should seek outside. I didn't like you, I didn't know what that meant. And so basically I meant talking to someone. And so I have since that time gotten with Acumen. I met with them in March, July, and October. Have other upcoming meetings with them. I believe everything's going well. Dr. Graham and I chat, and that's where I'm at.
Judge Cullins, you appreciate, do you not, that it's simply intolerable to have our judges abusing any employee in the entire system, right?
Yes, and I have to accept the panel's finding, but I think if you look at the balance of the people that testified, you'll find that that is not a normal situation. I've always tried to balance out my curtness, my bluntness, by talking to people. And I made an error in this play in this sense of talking to people too sternly, hoping that I could just get them back on the rails without anybody getting written up. I won't make that mistake again.
What assurance do we have of that you won't make that mistake again? Because I honestly don't accept the idea that I can be nice to 90 people and abusive to 2, and that's okay.
Well, I disagree with the panel's findings, but I'll accept them. I was overly stern with Lance, and I will accept the consequences for that. But by the same token, I think you have to understand that when I got on to Lance or Mr. Carter in this circumstance, I did it wrongly. I will agree with that. But I was trying to get him to correct some of his behavior without anybody getting written up. And then me and Lance, I thought, but I was wrong, continued to have a positive relationship after that. Lance and I continued to talk about cowboy games. I'd ask him what's going on. So I was under the misimpression, and I should have apologized to Lance, I guess, that I was too stern with Lance, but I was under the misimpression that we had returned to normal, even though I got too sternly on him. So, I mean, the same thing with Mrs. Pratt. When I got on to her, I would ask Mrs. Pratt all the time. She was a very new clerk, a new head clerk, never done the job before. Are you doing okay? So it's not like there's not a compassionate or a concerning side to me. I was overly stern when I got onto them.
And what assurance do we have that this will not happen again?
I can tell you it's not going to happen again. If you look at my history, that's not my history. That's not my history.
Judge Cullins, you've conceded that you say the F word frequently in the courthouse, outside the courthouse. It's no big deal, right?
I said the F word all the time, yes.
And you understand that could be, we're not even saying the word. You understand that can be extremely offensive to some people.
I understand that. A lot of people are not.
Did you have even one employee who confronted you directly and said, Judge Cullins, that is offensive to me?
No, except for when Mrs. Jones did say afterwards that somewhere at a time when Mrs. Jones said that I was offending Mrs. Pratt by the use of the word, and then I cut it down.
And do you understand that your power differential, which exists all the time, may be preventing people from confronting you with things that you do that make them uncomfortable?
I agree that the power differential can do that. And I think if I walked around aloof all the time, that people might believe that they couldn't approach me about those things, but I never have done that and won't do that.
Do you understand that raising your voice also may make people very uncomfortable?
Yes.
And do you understand the same power differential may prevent them from confronting you about that?
Yes. I understand that now. But at the time, I thought I was approachable.
What insights or developments have you obtained through the Acumen program? In other words, through the coaching, through the sessions, has that led you to any realizations about the alleged conduct and its impact on other folks in the workplace?
Well, when Mrs. Pratt initially made her complaint, you'll find that's the only complaint that I received a copy of. I immediately resigned as chief judge, because when I read that complaint, I was like, something's going wrong here. I don't understand why, like, Lance Carter's name's on there. I don't understand that. So, and at the time I was tired too. So I immediately recognized that something was going wrong. And I called Topeka. I asked for an investigation. And then I resigned from my position. I was told, don't worry about it. Mr. Thompson will come down and do an investigation. And so I immediately took steps, even before I met Acumen. I'm like, what did I mess up here? How did I go so wrong? And I hit the pause button. So I try to, through Acumen and through my own experiences, I try to note when I'm tired. You know, when you've had those days when you can't sleep, I try to hit the pause button. I try to remember that I can stop proceedings, but I have a natural tendency to want to march forward. But I remember that I can pause proceedings. I try to be less blunt and try to think of ways to phrase things differently than I would have before. I work on not being as stern. The courtroom can be a difficult place when you're the guy trying to maintain control. So I'm trying to find that balance between not being stern and keeping control of my courtroom at the times it might go disarray. I hope does that answer your question, Justice Wall?
Are there other questions? Okay, thank you. Mr. Thompson, you reserve 3 minutes.
I did, but I will waive those except to answer any questions anyone has.
Counsel,
Yes.
I guess my question is, from your perspective, would we be here if Judge Cullins had never said fuck or its derivatives?
Yes, I think we would. There was a turnover of employees. I mean, if he had not used obscenities, but ordered people to sit down and shut up and they weren't allowed to defend themselves and used loud and angry voices. And even if he hadn't used obscenities out in front of the carpet layers, his behavior still would have caused us to be here.
So the gravamen of the complaint is not dependent on the
I'm sorry.
We might have
Yeah.
lost your audio for a minute.
I'm sorry, my connection may be poor. I apologize. I was just summarizing what I understood you to answer, that the gravamen of your complaint does not depend upon the use of the obscenity.
It's not solely dependent upon the use of the F word, no.
Okay, thank you.
Are there other questions? Thank you to all of you for your arguments and presentations. We will take this matter under advisement. The docket, this week's docket is now adjourned. Thank you.
Thank you.